The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Be seated, please. Good morning and welcome to the Fourth Circuit. We're certainly getting our money's worth today on the heating, but we're in a government building, so it is what it is. So we'll hear argument in our first case, Critter versus Mooring, and we'll kind of gauge the temperature as we go through the morning and see if we have to take some breaks. So with that said, Mr. Chilson, we'll hear from you.
May it please the court, good morning. My name is John Chilson. Along with Tom Comerford, I represent Critter Crop Dusting and the estate of Eugene Critter in this premises liability negligence case in which we allege, and the defendants all agree, they failed to exercise due care in keeping an invited lawful visitor to their premises safe from a booby trap hazard. The issue before the court.
You say they concede that.
The record is clear that, and specifically I'm referring to deposition testimony by the defendants, they did not do an investigation for hazards. They were not supervised.
But the point is, you can't say they conceded, right? I mean, you weaken your own argument when you overstate your story, right? You may say that they conceded facts that show the following, but you begin your argument by saying they've conceded that they violated the duty of care. If they conceded that, we would not have a dispute here.
Well, Your Honor, what they say is that they did not have a duty, but their conduct, they've conceded their conduct is really what I meant. So,
The question is whether that conduct left any genuine material disputed facts on the question of whether there was a foreseeable duty on the part of the defendants.
yes, that's true, Your Honor. And so we can.
Why don't you tell us why that is?
Sure, we contend that there were a number of places in which the district court, the trial court, weighed the evidence and decided in favor of the moving party, the defendants in this case. I'll get into specifics and I can keep going, but the first one is Nutrien's duty. The court said that they had not engaged in an undertaking, that imposing liability was unwarranted on them, and that investigating and warning of hazards exceeded their scope of their calling. The record.
If the DAW defendants are not liable here, is Nutrien liable?
Yes, Your Honor. Nutrien is liable because they are a large international chemical sales company in which part of the.
Right, but they have to, under your theory as I understand it, Nutrien would have to have taken on an independent duty separate and apart from the DAW defendants, which could imply that the DAW defendants didn't have a duty.
Well, Your Honor, we contend that they both have duties. They're separate duties.
I understand that you make that claim, but you can see the contradiction there.
I can see the contradiction, Your Honor, because they both had very different roles in this case. The record is clear that Nutrien, as part of its business model, provides for the application of the chemicals that it sells to its customers. There are two non-party pilots in this case who have been deposed, Richard Wheeler and Dick Froman, and they both testified very clearly that they often spray for Nutrien and that they expect Nutrien sales reps who they usually meet, they say, instead of the landowner, to advise them of hazards on the properties.
So is there a place in the record that we can find where there's a contractual undertaking by Nutrien and what the terms of that contract are? What were they obligated to do? Where do we find that in the record?
So there is not a written contract. Instead, it's an implied understanding that goes along with the industry standards. And so there are numerous places in the record where there are references by
Is there
pilots.
a contract for the chemicals in the record?
No, Your Honor.
Was there a contract for the chemicals?
There was a sales receipt, yes. Yes. But there is testimony by Rodney Thomas, who is the only crop dusting expert in this case, on pages 2066 and 2067 of the joint appendix, that it is an industry standard for a crop consultant like Jordan Elmore to inform the pilot about hazards such as this cable. This cable was not something that a pilot is trained to see. The record shows that pilots are trained to look for multiple poles because that is from which wires will extend. This was a single pole. It was a booby trap hazard that was installed by one of the defendants.
In my mind, that leads to a central question that I'm not sure the parties or the district court particularly addressed. So I think the defendants would agree that they could certainly see this wire from the ground. And so would anybody else who was walking on the land. What made it reasonably foreseeable to them that the wire they saw would not be just as visible from the air?
Well, we contend that the law requires a landowner or occupier to investigate their premises to make sure that it's safe for lawful visitors from hidden dangers. In this case, as I said earlier, there is no evidence that any of the defendants exercised any due care to investigate the property. The reason for that rule, the reason the law requires an investigation by a landowner or occupier is because
in response, I'm not sure you're answering this question, but you think they needed to get in a helicopter and go look to see whether the wire was visible from the air?
No, Your Honor. The landowners are the experts of their own property. They are the experts of what is on their property. They had access to the property. Nutrien, through Mr. Elmore, in addition to the DAWs.
But maybe I'm wrong, but can you try to answer his question? I'll rephrase it for you. So the landowners, I just thought it was a good question, so I want to get your take on it. The landowners look and they can see the wire, right? We know they can see the wire from the ground.
Right.
The question is, why is it foreseeable to them that it's not just as visible from the air? Like what?
Sure.
Why would a farmer be like, I see the wire, right? There's a pole, there's a wire.
Yeah.
Right? Why would they then think, I understand why they might understand it's a danger, but why would they think, well, a pilot's not going to be able to see the thing that I can see?
Because if they inspect as they're required to do, then they view
They don't
the
need
obstacle.
to inspect it, right? They see it. I mean, they're looking at the thing.
Well, they would view the obstacle in the context of what the lawful visitor is there to do. In this case, if they looked at the wire in preparation for Mr. Critter's arrival from the ground, they knew from previous experience with crop dusters at which height they fly over the cornfield. They would have also then looked and said, oh, that wire, which we knew about, that wire is about the same height above the corn as a crop duster will fly.
Mr. Chilson, is this issue of foreseeability a question of law for the judge or a question of fact for the jury?
Your Honor, in this case, there are so many material facts that it is a question of fact for the jury.
And is it part of the duty of care or is it part of causation?
It could be both, depending on how you read the cases.
Under
but
North Carolina law,
it's duty.
the issue of foreseeability under North Carolina is a part of the duty of care? Is that what you're
Well, in
suggesting?
order for the duty to exist, the hazard has to be reasonably foreseeable, meaning they knew or should have known, which is one thing that we contend was missed in the district court's opinion. Whether or not a jury, with looking at all the facts presented, would determine not just that they knew, but that they should have known had they performed this investigation. And in that case, they would have a duty.
So you're
but it would be a
suggesting
jury
that duty of
question.
care is a mixed question?
Yes, I do. Yes, Your Honor. So there are, Judge Agee, there are a number of other places in the record where there are mixed questions of fact, where the court concluded as a matter of law.
What's your best evidence to create a disputed issue of material fact that defendants knew that this wire would be a hazard from the air?
We contend that a jury could determine that they should have known that it was a hazard from the air because they installed the wire in one of the defendant's cases. They knew that the wire was present. They all had familiarity over many years, and including with this crop duster, in observing crop dusting operations. Mr. Elmore recognized that there is no difference between a helicopter crop duster and a fixed-wing crop duster. They both fly low over the fields to apply the chemicals. That is exactly where this wire was located. It was something that was there. It had.
The deer stand was there too. What would have happened if the decedent had flown into the deer stand?
Then we recognize that the pole itself was a hazard. And the pilot, Mr. Critter, saw the hazard, according to the record. So if he had flown into it, then I believe that he would have been contributory negligent.
Same thing if he'd hit the pole.
The pole, yes, Your Honor.
So it's not uncommon for poles, particularly in rural areas, to have wires strung from them. Why would it have been reasonably foreseeable to the defendants that that would not be common knowledge?
Your Honor, the reason is because this is a unique setup. This is not a situation where there are two poles from which a pilot would expect a wire to be hanging. It's not a situation
I mean, have you ever been in a dove field?
I have been in this field, yes, Your Honor.
I mean, you sit in lots of dove fields that are not electrical wires, right? They have a pole and they run a wire because the doves like to sit on it, right, before they come into the field to eat. That's not like a terribly uncommon. I mean, you say this is uncommon. I happen to sit in several that look a lot like this. And so now maybe I take that might be a fact question and you might just lose before a reasonable jury that's familiar with dove fields. But to say it's unique seems like mistaken here, right?
Well, Your Honor, with all due respect, this wire extended from a pole where there was a deer stand ladder across the top of a field into a woods of mature trees, which was on the eastern side of the field, where it was connected to a mature tree. So the evidence is that Mr. Critter did not see the tree. So in other words, he had no reason to believe that there was anything other than a deer stand attached to this pole.
Your argument is if there were two poles in a field, then he would have been on notice, and maybe we're probably talking about jury questions mostly, but in that instance, any reasonable pilot would understand when you got two poles, there's likely a wire. But your view is that no reasonable pilot would see one pole in the middle of a field and think that the wire was tied off to something other than a telephone pole.
That's right, Your Honor, and that's what all of the crop duster pilots who've testified in the case have said in their testimony, which is there would have been no reason for a crop duster exercising reasonable judgment to look at that individual pole and see that ladder there and think that it's anything other than a deer stand.
Oh, no, I've been in an awful lot of deer stands over time. I've never been in one with a telephone pole attached, but that's neither here nor there. So let me ask you, going back to the Nutrien and Elmore defendants, is the material dispute a fact here in your view that the terms of their engagement are in dispute, what they undertook to do?
Your Honor, there was the evidence in the record suggests that it's very common for Nutrien and its competitors to provide a service along with the sale of its chemicals, whether it's aerial application or ground application. Mr. Elmore testified himself that 20% of his customers use aerial application. Mr. Wheeler, who flied over this field in 2019, was connected to this field because it had been flying at another field for Nutrien. The two pilots who are not parties to this case and plaintiff's expert crop dusting pilot, Mr. Thomas, all testified that it is common for them to meet with a Nutrien rep as opposed to a farmer who they understand represents not only the farm, but is speaking for the farm. That person, by custom, by industry custom, advises them of hazards in the fields. That's what their testimony is. It's that part of the custom is that Nutrien provides a service through their employee, Mr. Elmore, and when they do that, they're expected to exercise due care because they have engaged in an undertaking.
So that's your proffered evidence. They say, no, we didn't agree to do that. All we were going to do is deliver some chemicals, and there's the factual dispute.
Yes, Your Honor.
Okay.
That's right. So, Your Honor, I see I have 18 seconds to go. Would you like me to continue or have a seat?
That's up to you. You do what you want.
Okay. Thank you, Your Honor. I'll sit, and I've reserved 5 minutes for rebuttal. Thank you.
All right, thank you very much. We'll now hear from Mr. Brock.
Yes, Your Honor. Good morning. Walter Brock from the Wake County, North Carolina Bar. I will be arguing on behalf of the farmer defendants, and my colleague, Mr. Hogan, will be arguing on behalf of Nutrien and Mr. Elmore. We submit, Your Honor, that there are 2 reasons why the district court should be affirmed. They're 2 sides of the same coin. The first side is there's no duty of these farmers to warn of what turns out to be a very unique aeronautical hazard. The farmers had no way of knowing that that presented an aeronautical hazard. Secondly, we believe that the evidence establishes that the plaintiff, Mr. Critter, was contributorily negligent as a matter of law for reasons that were not directly addressed by the district court. We also submit there really aren't any facts to resolve.
The district court, if I remember, found that the contributory negligence was not present in this case.
No,
At least at summary judgment.
What he concluded was that because there was evidence in the record that the wires were hard to see from the air, then that's an issue of fact. We submit that was the wrong focus on the contributory negligence issue. We submit that the focus on the contributory negligence issue is that the pilot was aware of the hazard of the pole, a 32-foot pole in the field. That's not a pole for a deer stand. We all know that. The deer stand, the record shows, was 10 feet high.
So take that if I was on a jury, I'd be a pretty good one for you. Help me understand why these aren't just jury arguments, right? I totally get your argument. If you see a pole in the middle of the field, a reasonable person would believe that that pole was there for a reason other than the deer stand, that there would be a wire going somewhere. I totally get that. But, there's an argument on the other side that that's not what a reasonable person would do. People could sort of disagree about that. I totally get your jury argument, but help me understand why that's a summary judgment argument.
Right. It's a summary judgment argument, Your Honor, because of what this court put their fingers on is the unique nature of this hazard. The farmers knew there was a 32-foot pole in the field, and they knew there was a dove wire there. Under North Carolina law, you have a duty to warn only of hidden or concealed dangers. So the examination of the evidence should be, I submit.
But there's some evidence, right? There's evidence that the wire was not visible, and they put in evidence of the drone that was flying around or whatever we want to say about the evidence. But there was evidence, right? And the question is, what does the jury believe?
That makes my point, Your Honor. The fact that they had to engage expert witnesses and drone footage to demonstrate that from the air, these wires were not visible. But everybody knows from the ground, they're perfectly visible. The argument was...
That's a duty question, right? So
it is, and that is...
We're talking about contributory negligence, right? And so the contributory negligence question, it just comes from different sides of the angle, right? It's
two sides of the same coin, Your Honor.
Maybe it's not the same coin, right? It's definitely 2 different sides. The coins might look a little different, right? Because the contributory negligence question comes from the perspective of the pilot, right? And so asking whether it's visible from the air seems like the right question in a contributory question, maybe not the duty question.
With all due respect, I submit that's not the question. Our argument is, the question is, was the pilot aware of the hazard of the pole that was 32 feet high in the field? And he was.
And from that, was he required to then surmise that there must be a wire?
He must, under all guidance, FAA, he should eliminate the possibility that there's a wire, because all of that guidance says if there's a pole, assume there's a wire unless you can establish otherwise. He didn't, and here's how he didn't. Because also the guidance says, and the North Carolina.
You're still on the contributory negligence point here.
Right, I am. The guidance.
I have to come back to the foreseeable duty of the defendants.
I'm glad to do that.
And I also want to
May I?
remind us that we're in North Carolina, and the North
Correct.
Carolina Supreme Court has said repeatedly and unequivocally that it is in exceptional negligence cases that summary judgment is appropriate. So explain to us why this is an exceptional case where summary judgment is appropriate in a negligence case where North Carolina Supreme Court has
Right.
said repeatedly only in extraordinary circumstances is summary judgment appropriate.
Okay. We're going back to the duty question at this point. This is an exceptional case because it's the unique circumstance where the farmers had no way of knowing, without having the expertise of pilots, that what was obvious to them was not also obvious to the pilot. Duty is, if there are no disputed facts, duty is a question of law, and the district court recognized that, and the district court recognized that on this evidence, on this record, there is not a fair inference to go to a jury because there are no disputes about what the facts are. There's no.
Well, there is a dispute about whether the reasonable farmer would know that this was a hazard.
Yeah,
right?
and
that's a factual dispute.
Well, I think that is a mixed fact and law question, but it's a conclusion from what are known as the undisputed facts. The facts about who knew what, who did what, when, none of that is in dispute. If we were to ask, what is the fact that's in dispute? The only fact is whether there was or was not foreseeability, and that makes it a pure question of law if the reasonable inferences cannot be placed in favor of the plaintiff.
And we have to draw all inferences in favor of the non-moving party.
Absolutely, you have to do that. But
The plaintiffs here, though, seem to be, I don't want to not characterize their argument correctly, but they seem to make an argument that lawyers might call a pattern and practice, that the defendants knew from prior crop dusting experience that there would be aerial hazards that would not be ground-based hazards, and that creates a jury question in this case.
Yeah. They argue that, but there are no facts to support that they were aware that there's a difference between a ground hazard and an aerial hazard. They argue we saw crop dusting take place in the past, but there's no evidence that we were aware of a hazard. And these fields had been crop dusted for years, and there was never.
Do you have to have evidence that a wire is a hazard to a helicopter? I mean, that it strikes me that that's not one of those things that requires evidence, right? That we can envision a reasonable person recognizing that a wire and rotary blades don't mix well. That doesn't require evidence, right? That's the inference.
But the duty is to warn of a hazard that is hidden or concealed.
Totally get that, but that's a different point than the one you were trying to make.
Yeah, but to the farmers, what's the evidence that the farmers knew that the wires and the pole were hidden hazards? That's the rub.
Okay, so you agree that if they knew it was hidden, that they understood that this was an aeronautical risk, that it was an aeronautical hazard if it was hidden? You agree that they understood that a helicopter and a wire don't mix?
I don't know that they ever thought of that, Your Honor. I don't know that I can concede a fact like that.
Okay,
Well-
that's what I thought I think you were making both arguments, but when I asked you about one question, you answered with the other, right?
Well, I'm sorry. I apologize for that.
So my question is, why do you think it's beyond argument that the farmers here could not have foreseen that a wire would be a danger to a crop dusting helicopter or maybe a fixed wing? Is it only because it's hidden, or is there another reason you think they were not foreseeing that risk?
I think the duty only applies, Your Honor, to warn if one has reason to believe that it is a hidden or concealed danger. I think they could have imagined, well, if a helicopter hits...
Hypothetically, this is not the facts of this case,
Right.
but hypothetically imagine that your clients had written emails and testified on the Bible that they knew the wire was hidden, right? So we know from previous facts that they knew the wire was hidden. Do you agree in that scenario that they would have had to provide a warning to the helicopter pilot?
I do.
Okay.
I do. We submit there's no inference from these facts that they knew the wire was hidden. And I think that a really interesting thing is...
Well, didn't one of the defendants testify that they had seen crop dusting fixed wing aircraft fly over a field and they were so low that the understructure had beams on it?
That's true. That's true. And we accept the inferences of that, but that doesn't create the inference that they knew that the wire and the pole were a hidden danger that required a warning. They must know that it's a hidden or concealed danger to have a duty under North Carolina law, and it doesn't help.
And your view is the only inference we can draw from the record is that they had no idea that somebody wouldn't be able to see that wire. I mean, that they had no idea that somebody visiting that area in an airplane would not be able to see the wire.
I don't think there's any evidence that creates a fair inference that that's the case, Your Honor. We submit.
But that's what your case rises and falls on, that idea.
Well, I think, yes, in a sense, because the duty under North Carolina law is to warn of a hidden or concealed danger. Had they been told by the helicopter pilot, hey, are there any wires on this field? Because you know what? I can't see them from the air like you can see them from the ground. We'd have a different case. But because the law is what the law is, we submit there's no reasonable inference from any of this evidence that they appreciated or had reason to appreciate that these wires, obvious to them, this wire and this pole obvious to them was not equally obvious to anybody else using that. And of course...
Can I ask just a clarification? I think is a clarification question.
Okay.
In theory, Rayburn, who was the farm owner, could argue that it was not foreseeable to him that crop dusting would take place?
For sure.
Is that the argument that you've made? I mean, our focus has not been on that question. Your briefing seems to combine Rayburn and the farm. And I didn't see sort of the separate argument that Rayburn could not, there are two steps, right? You have to anticipate that there's a crop dusting going on, and then you have to anticipate that the wire is a hidden danger. I understand the second argument. We've talked a lot about that. I didn't understand you to be making or have made the separate argument that Rayburn, unlike the farmers, who obviously knew that crop dusting was taking place, that he could not have foreseen that crop dusting was taking place.
Well, we've made the argument in the brief, Your Honor. I haven't gotten to that here, but certainly that is the case.
You think that argument was made in the district court and was made in the briefing here?
It was. it was made in the briefing because it was pointed out, he was
Do you
retired.
happen to know where in the briefing you make that argument? With respect to Rayburn?
I wish I knew the briefing page numbers well enough, Your Honor. But that is an argument. He didn't even know there was crop dusting to take place. Moreover, he didn't, there's no evidence in the record that he had any crop dusting done in that field at all. So there's no
It's
record.
Under that division of argument, for instance, the estate of Rayburn Daw could be out under summary judgment, but Daw Farms and the other Daw defendants would stay in.
If the court rejects my argument about the duty in terms of not being sufficient evidence that the farmers had reason to believe that a pole and wire that was obvious to them was not obvious to others, and the court draws that distinction, I think the court could reach that conclusion. We submit that open and that obvious nature covers all of the farmer defendants. I see my time is up.
All right, thank you very much.
Thank you.
Mr. Brock, we'll hear from Mr. Hogan now.
Good morning. May it please the court. The claims against Nutrient Ag Solutions and its salesman and crop consultant are even more tenuous than they are against the farmers. These are not landowners. These are not occupiers of land. They didn't control the land. And engaging in the mere undertaking of scheduling a crop dusting operation does not impose upon a crop consultant a duty to know what only a pilot will know.
Although I understand the plaintiff's argument to be that there was evidence from different witnesses that the engagement of Nutrient was more extensive with that. And if that's the case, why wouldn't that be just a classic jury factual question? What was Nutrient and Elmore engaged to do?
Sure. As the district court noted, they were engaged to they scheduled the crop dusting, they identified the fields, and they provided the chemical. That was the scope of the undertaking, and the scope of the undertaking determines the scope of the duty. And there is
Isn't that the extent of this undertaking? Right? I mean, you say like they only did these three things, right? But that's the entirety of that side of the undertaking, right?
Sure.
That's all that happened on that side.
That's all that Mr. Elmore did on behalf of Nutrient, and all Nutrient did was really supply the chemical, right? And
The plaintiffs say that if on tradition and custom, for no other reason, there was more to it than that it would be a normal expectation in that trade, in that part of the country, that the supplier or the agent for the crop dusting services would undertake to do more than simply deliver the chemicals, and that it's a factual dispute as to what they agreed to do.
Judge Agee, there is not a shred of evidence in the record that they agreed to do more than that, and the only thing that they cited was expert Thomas's offhand comment that this was an industry standard. But there is zero evidence that any crop consultant ever provided helicopters with a briefing on what might be a hazard to them. And the reason for that is...
But isn't there evidence that Critter actually asked Elmore right before he flew whether there was anything he needed to be aware of on the farm? He specifically asked that question?
So the district court addresses this shred of evidence in footnote 8 and of its opinion. And this was not before he flew. This was after he had completed the spraying of numerous fields. And the district court rejected the notion that that call was about a hazard because there was a mountain of evidence that it had to do with other issues that the pilot should be aware of, like a subdivision that was on the north end of the field. Be careful, don't spray there because there's a risk of drift. right? And there's
That sounds like a fact question and an inference to me.
even if you accept that as a call midway through about a hazard, that doesn't change the analysis, because there is no question that there is zero evidence that any of the
Who told
defendants.
Critter about the subdivision? Does the record tell
Elmore.
us who communicated with Critter about the subdivision and the possibility of drift, as you indicated?
There was a text between Mr. Critter and Mr. Elmore about.
That was Mr. Elmore.
Yes, it was. But again, going back to the foreseeability, which is a critical component of looking at not just the scope of the undertaking, giving rise to a scope of duty, but what is foreseeable in discharging your undertaking. And there is no evidence in the record that Mr. Elmore appreciated that this wire would suddenly become invisible from a helicopter. Nobody knew that. If Mr. Wheeler from 2019, who had the close call, had called up Mr. Elmore and said, hey, look, I almost hit this wire. It disappears when you're in the cockpit of a helicopter. I know you can see it from the ground, but you cannot see it when you're in a helicopter. We have a different case. That's a different story. That's actual knowledge. There's no evidence of that.
But actual knowledge isn't required, right?
Actual for a premises liability claim, Mr. Elmore and Nutrien certainly have no obligation to inspect thousands and thousands of acres of farm that they organize to have a crop duster come and spray. I mean, that is not only physically impossible. I see my time is up, Mr. AG.
Judge Berner's question.
Not only is that physically impossible for a crop consultant to inspect thousands of acres, but it's also impossible from a knowledge standpoint to impose upon a crop consultant to understand what constitutes a hazard to a pilot in a highly regulated and specialized industry. Foisting that kind of duty upon a crop consultant would do away with this sort of crop dusting service that they provide to farmers to allow them to complete their jobs.
All right, thank you very much.
Thank you.
We'll now hear Mr. Chilson's rebuttal.
May it please the court, I'd like to start with Delenar Dawes' duty. There's an interesting passage in John Anderson's deposition where Mr. Anderson got lost on the way to the staging area for the spraying of this particular field. The testimony is that he was about 2 miles from the site going in the wrong direction when he ran into an older fella that he was told later was Mr. Daw. Mr. Daw said, I know who you are. You need to go back that way, and then gave him instructions back there. We believe, or a jury could believe, that that was Delenar Daw because Rayburn Daw did not testify that he had ever encountered any of the Critter folks. That exchange, that dialogue can be found in the joint appendix on pages 294, 295, 297 through 299. I think one of the things that tends to get lost in this case.
There's a lot of Daws in this case. So
Yes.
That's one of the Daws of the Daw Farms.
That's the Mr. Daw who owned the field, who erected the pole and the wire.
So you're saying that there's a deposition testimony that he told the Critter's crew member to go back the other way?
Yes, Your Honor. And what it does is it allows a jury to make a reasonable inference that Mr. Daw, the landowner, was aware that the crop dusters were present that day to spray the fields. And where they were spraying because he directed them back towards the potato barn, which is very close to his field. One of the things that I think gets missed in this case is that
I'm sorry, I confess, maybe I just have them confused. The person who owned this field, his first name was what?
Rayburn.
Okay.
Did I misspeak? I apologize.
No, I confess. I
have the same problem, Your Honor.
Okay.
I'm sorry.
And so tell me what Delenar Daw, he owns the farm company.
Yes, and he owns the field next to it, yes, where Jordan Elmore was riding on a combine when he
Okay.
saw the wire.
All right, I think I understand. So tell me why it matters that Delano Dahl knew that the crop duster was coming?
Well-
Why is that? You chose to lead off with that,
Sure,
so I'm
sure.
trying to figure out why that matters.
Well, I was responding to the argument that seemed to be that because Delano didn't know about this spray operation, that he therefore may not have been reasonably foreseeable to him that a crop duster would be present. That was.
But everybody knows that the farm knew about this. The question is whether Rayburn knew about it,
Yes, Your Honor, and if he told Mr. Critter's crew,
but not Rayburn. You just said Delano.
Murray is how I refer to him. I guess that's the confusion. The owner of the field. The owner of the company has not testified that he had any interaction with any of the Critter folks. So Mr. Daw, who did have an interaction, a reasonable jury could infer that it was the owner of the field.
Murray Rayburn.
Yes. Yes, Your Honor.
And there was no lease agreement between the parties, is that right?
It was an oral agreement. That's right.
And what does North Carolina law say about that?
It's still a valid lease as long as the terms are complied with. And
But Mr. Rayburn maintained access to the property and used it from time to time.
he sure did, Your Honor. There was a lock and key that he maintained control to, and there's testimony in the case, in the record, that he was very particular about who had access to his fields.
So both Mr. Rayburn and Daw Farms had access to the property and used the property in this time period.
That's right.
So if we were to find a duty of care, it would be to both.
Yes, because it's a non-delegable duty, and that's one of the things in this case, is that they seem to be wanting to delegate the duty to inspect, the duty to supervise, the duty to keep the premises clear to the lawful visitor, Mr. Critter. Premises liability law in North Carolina is clear that the duty is non-delegable for the landowner and the land occupier in this case. So, and there are other duties. It's not just to warn. The duty is to keep safe, to take reasonable efforts to keep the property safe from hazards to lawful visitors. And within it, there's also a duty to behave reasonably, which would include removing hazards and to mark or warn of those hazards if they can't be removed.
So can you go back and recap? What exactly is the jury question when it comes to the nutrient defendants?
Yes, Your Honor, and I am out of time. Okay. So the jury question for regarding the nutrient defendants and Mr. Ilmore is that based on the evidence in the record that Nutrien oftentimes arranged for crop dusting services as a service that went along with their sale of their chemicals to their customers. And because pilots in the case have testified in the record that oftentimes they only meet with a representative from Nutrien as opposed to an owner or an occupier of the grounds, and because that that discussion often involves safety, and because these non-party witnesses expect that the Nutrien representative from their custom and their experience will warn of hidden dangers in the fields, that is a jury question whether or not they had a duty and breached that duty to Mr. Critter.
So in effect, the jury question is, since there's no written contract, was there effectively a custom and practice in that trade to undertake to do more things than simply deliver the chemicals?
Yes, Your Honor.
Okay. All right. Thank you very much.
Thank you.
Yeah. You're okay. All right. We're going to come down and greet counsel and move on to our next case. All right, we'll now hear argument in our next case, which is Banco Mercantil. Mr. Cassidy.
Thank you, Your Honor, and may it please the court. In terms of vocabulary, I'll be referring to my client as Cartograf. They are Cartograf USA. They were a company in Virginia. They're no longer in existence, and that's in part because they did not file their taxes. Generally, I'll be also speaking about the opposing party as Becerra, which is a bank originally located in Mexico. Cartograf is asking this court to reverse and deny or reverse and remand the district court's order granting a 1782 application. And we're asking the court to do this in part because there appears to be somewhat of a gap in the law.
Can I just ask a question? You just said that your entity doesn't exist. Then how can we resolve a case about an entity that doesn't exist?
Although it technically does not exist, we're still subject to the jurisdiction of the Virginia court. There are still legal proceedings going on in that court related to this. Although it doesn't have a license in the state of Virginia, it is still winding up, as it were, not just in federal court, but also in state court, where the property is in the process of being judicially sold.
So under Virginia law, the board of directors of that company would be charged with winding down the business. Is that what they're doing now?
That's correct, Your Honor. And this issue came up in particular because Becerra wanted to get additional information here in the United States from a U.S. company to use in a foreign proceeding in Mexico. Where is the gap in the law? The gap in the law is in this case found because Becerra has identified both civil proceedings and specific criminal proceedings in Mexico that it has brought against the ultimate manager and owner of Cartograf USA. Now,
what in the record do I look for to understand that a private party can bring a criminal proceeding? Right. So in the American system, we operate in a world where a private party can ask that a criminal proceeding be brought. They can provide information to a prosecutor, but it's been an awfully long time since in the U.S. system a private party can actually go before a grand jury and bring a criminal prosecution. You seem to assume in your briefing that a private party can bring a criminal action in Mexico. Why is that?
well, Your Honor.
Not just the motivating factor, but they have to actually be the one bringing it, right?
Yes, and that issue was not actually briefed in the lower court. Yes, we can talk about experience, and I can tell you that is the case. But if you're looking for a cite in the record, the only and best cite would be the Marin Declaration, which is the declaration supporting Becerra's application. And in that declaration, Mr. Marin states that one of the Becerra entities have in fact brought criminal proceedings against Juan Jose Paramore, who is the ultimate owner of Cartograf USA. And you can find that in the appendix. His declaration and the definition of foreign proceedings is at page 57 and 58. And that's really the issue here. They define, in asking for discovery, they define exactly what they want, and they say there are a number of civil proceedings and then a number of criminal proceedings in Mexico. And the Marin Declaration...
Number of criminal proceedings or one?
Well, that is the great mystery. The reason we're here is because...
Well, I mean, is there evidence in the record there's more than one criminal proceeding?
In my position, Your Honor, I would say no, but it really depends on how you read the language in the Marin Declaration. And in that paragraph 22, which is on JA 57 and 58, Mr. Marin says that they have initiated a criminal proceeding against Juan Jose Paramore. But I think it's general enough that it's unclear. And that's really our issue here.
So you think we should read A there to be more than one? I mean, that'd be an unusual reading, wouldn't it?
I agree, Your Honor. It's the generality of the statement as a whole. I'd be hesitant, and I think it's really a question probably for Benorta more than it is for me, but I'd be hesitant to try to get too much specificity about these proceedings, and that's exactly why we object in part to the district judge's order. We don't know what the for-use purpose of this discovery will be in those criminal proceedings. Now, Benorta has taken a very direct line. Once we filed our objection to their attempt to get this subpoena, they filed a reply, and in that reply, in their pleading, they say, we will not use any of this discovery in the criminal proceedings in Mexico. In fact, we're only going to use it for the civil proceedings. But that statement in pleadings is directly contrary to the whole basis of the application, which is Mr. Marin's declaration. He signed a declaration under the penalty of perjury stating that there are, in fact, criminal proceedings in Mexico. And yet,
And just so I understand what you're talking about, you're talking about on paragraph 22 on page 58, where they say that they filed a criminal complaint?
Yes, sir.
And you're from that drawing that that is a criminal proceeding? And why are you drawing that as a criminal proceeding? I mean, so I can file a complaint, right? I'm going to go down to the police station and tell them that Judge Agee has assaulted me, right? And so I file a complaint based on that assault. But that's not a criminal proceeding unless and until, they bring some action against him.
And, Your Honor, I think you're absolutely correct. And I do not want you to think I'm trying to misstate or overstate our position. The question is, what do they mean by that paragraph? Because those criminal proceedings are part of the overall Mexican proceedings that they're requesting this discovery for. And what we want to know, since they don't specify the use...
Other than that paragraph, you've got reams of documents that talk about the civil aspects of their case. It seems like because you have this one kind of throwaway line about there's also a criminal proceeding, it invalidates all of the civil objectives.
I would not go so far as to say it invalidates the civil objectives. What I would say is that the district court cannot fulfill its role as a gatekeeper and determine what documents may be used in this criminal proceeding unless Benorta is required to simply tell us. If you're going to define the Mexican proceedings, as they do in the Marin deposition, to include criminal proceedings in Mexico, then there has to be a level of detail that is given.
Well, so, if they say whatever we get, we're not going to use it in the criminal proceedings. Why isn't that the end of it?
It's directly contrary to the Marin Declaration, which is the support for the application. If Mr. Marin had come back and done a supplemental...
What is it? Where in the Marin Declaration? Is it inconsistent? I actually don't understand that argument at all.
And I apologize. Let me see if I can flesh it out a little bit. We know that there's something criminal going on in Mexico. We don't have the details. For the district court to determine whether the requested discovery will be used to circumvent certain protections in Mexico or whether it will violate a privilege in Mexico, we need to have more details about the action. And that is exactly what In Re Turk says. You have to provide...
The action there, you're referring to what you claim is a criminal proceeding, which he describes as a complaint that was filed.
Yes, sir. And again, I do appreciate and agree with your distinction. We can call it a criminal complaint. Given the fact that that criminal complaint is part of the basis, the definition of the Mexican proceedings that they are using to request this information under In Re Turk, they are required to give us some level of detail. Why is that important? As you know, one of the things that Cartograf USA wanted to do was invoke its privilege as a company against self-incrimination. And that is a right given to companies in Mexico that typically is not given here in the United States. However,
if the district court's order had said, I'm going to give you all the things you want, use them as you wish in the civil proceeding, but you can't use them in the criminal proceeding, you'd be done?
Yes, sir, I think we would be, and I think that's consistent with the Fourth Circuit's decision in Ray Newbrook Shipping Corporation.
And does it require, in your mind, So that argument to me seems to turn on the notion that a private party can prosecute a criminal offense in Mexico, which seems antithetical to like everything I know about their system, but I'm no Mexican expert, right? So that a private party can't use anything in a criminal proceeding, right? The prosecutor uses things in a criminal proceeding. So to say the bank is going to use something in a criminal proceeding seems antithetical. At least, let me just say, in the American system, the bank cannot use something in a criminal proceeding, right? The government uses something in a criminal proceeding.
That's absolutely.
And so what I don't see is any reason to think that Mexico has a different system than that, right? Your argument is premised on this notion that the bank can itself individually prosecute somebody and use evidence against a defendant in Mexico. That's the premise of, I think, this entire argument, and I don't understand why that premise has any support in the record.
I would go back to the paragraph that we've been discussing.
Is there anything other than the I understand that argument. Is there anything other than the paragraph to support your premise that a private party can use evidence to criminally prosecute another private party under Mexican law?
No, issue was not raised in the district court. That is not our argument. Our argument is that Mr. Marin is the one who says there is a criminal complaint. And under both In re Turk, and I'd also argue the Fourth Circuit and Newbrook Shipping Company, they are required to give us details of that complaint and that proceeding. Therefore, that would allow Cartograf USA to, one, object or not object, assert a privilege or not assert a privilege. And, as the panel has already said, yes, something as simple as giving the requisite details so Cartograf USA can fully defend itself, either comply with the subpoena or assert the relevant privileges, would have ended this. I'm still a little bit shocked that when we raised this issue, instead of simply saying, here's the cause number, this is what's going on down in Mexico, they said, they made an about face and said, absolutely, well, we're just not going to use it in the actual criminal proceedings. But they didn't. That's in their filing. That's not Mr. Marin. Mr. Marin is very clear. There is a criminal complaint.
Well, if they've represented that to the court, what else is there to do?
I think some kind of sworn statement by a witness making that statement is important because Mr. Marin.
What is the basis for that requirement? So why, I understand you would like it, right? But what is the basis? What rule or principle would I look to say that we don't take the representation made by counsel, but we require a sworn statement?
I'm not pointing to a rule. I'm arguing that the representation made by counsel in filings contradicts Mr. Marin, his declaration, where he defines that criminal complaint as part of the Mexican proceedings that are the basis for requesting the documents. Mr. Marin is the one who says the criminal complaint is part of the Mexican proceedings. It's part of that definition. That's why they want the documents. All we're saying is, if you're going to request the documents, the for-use prong of the test requires you to tell us what you're going to use these documents for in the criminal proceeding.
But is it possible that Banorte didn't provide more details about the criminal proceedings because they didn't have more details? The In re Turkey case that you keep citing, which by the way is unpublished district court opinion out of the circuit,
I'm aware.
was a private party made the request, not the government. So here it's a private party, and perhaps the private party simply had no further information.
The fact that it's in a declaration under the penalty of perjury and it is used as part of the definition of the Mexican proceedings is sufficient to raise the issue. Now, if Mr. Marin wants to now say he doesn't have any information about the criminal complaint that they filed, that's fine, but there has to be some level of detail about what exactly these documents are going to be used for.
So if counsel today in a few minutes tells us, yes, we represent to the court, we're not going to use any of this information in the criminal proceeding in Mexico, why isn't the case over?
I think that representation is inconsistent with Marin's declaration. I have tremendous respect for counsel, but at the end of the day, we have a sworn declaration that is specifically saying that they have filed a criminal complaint. And what we are asking is really simple. Give us those details. So if we're going to assert a privilege, as we did, we can do so with the details and the facts that are necessary to apply that privilege.
Thank you very much. You've got some rebuttal time coming.
Thank you, Your Honor.
All right, Ms. Major. So why don't we start by asking you whether or not you represent to the court that whatever materials you may get under this statutory entitlement would not be used in the Mexican criminal proceeding.
As the Banorte parties have said in all of their briefings, we have no intention to use these documents in criminal proceedings, only civil proceedings in Mexico.
And you, as counsel, are making that representation to the court today.
Correct.
Can you answer my question of whether, like, that's even a useful question to ask? Like, under Mexican procedure, like, can the bank prosecute a private citizen for a criminal offense?
So to my understanding, the way this works in Mexican law is one of the three Banorte parties filed a criminal complaint, and at that point, the government takes over. Theoretically, I mean...
And so if it goes to trial, the only people that could use these documents in any criminal proceeding would be the government or the defendant.
To my understanding, yes.
Right. I mean, the point being is that, like, it doesn't make a ton of sense to think about a private party using documents in a criminal proceeding because a private party can't introduce documents. There's no intervention of a private party into a criminal proceeding such that would allow them to use them. My point being is that I understand you're answering a question and saying, we're not gonna, which is, I think, totally the right thing. That's the question he asked you. My point is even if you wanted to, it doesn't seem to me that you could, which makes your answer, like, particularly easy, it seems.
Right, and I'm not an expert in Mexican law, but that is my understanding of the way the Mexican proceedings work.
So in effect, you aren't going to, or your client is not going to tender this to the government on your own, but what the government may do later on of its own volition is we don't control that.
Right. We've been representing from the beginning that we have no intention to do that, and that hasn't changed.
Could the district court restrict the use of the subpoena to the civil dispute?
The district court could do that. I do not think that they should. The district, at the motion to quash proceedings, Cartograf USA did not raise the issue of a protective order. It did not ask the district court for a protective order, a confidentiality order. So the district court was not required or even asked to put that into place. Certainly, though, it could have. It could.
So the district court did have, as part of its order, a protection clause regarding tax matters.
That is correct.
So you're saying that should be a question for the opposing counsel, but I'll ask you anyway. They ask for tax information protection, but not for criminal proceeding protection in the order.
Right.
That's correct?
Yes. They made an argument that they should not be required, that they should be protected from the requirement to provide tax records, and the district court granted that. And the district court's opinion was a thorough, nuanced opinion. It was 26 pages. It thoroughly dissected all of the arguments being made by Cartograf USA today, except for the protective order, because that wasn't raised. And the district court did not abuse its discretion with relation to the application of the statutory factors. With respect to the for-use prong, you just heard from counsel that there's no dispute that the Banorte parties successfully met the statutory factors, the discretionary intel factors with relation to the civil proceedings. That is where the district court's analysis ends with regard to a 1782 application. Cartograf USA just said that they do not dispute that as well in their briefing. There's no argument against it. So whatever this court does here today should not disturb the district court's findings with relation to the civil proceedings.
But so in America, and I'm drawing analogies to the American system because I don't know much about the Mexican system. But, even in a civil proceeding, you can still assert a right of self-incrimination if it's reasonably likely that a criminal prosecution might follow. And we sort of got that type of a system. So if this was an American story, they could still, in theory, assert a privilege. They would lose that, I think, under American law. But tell me why the district court got it right in evaluating this privilege issue. I mean, they've asserted that that this Cartograf USA is not required to turn over its corporate records because a shareholder might be prosecuted in Mexico. Tell me why you think that privilege argument fails. Sort of, it's a little bit separate from the arguments we've been focused on.
Yes. So, absent authoritative proof of a foreign privilege, a district court is not supposed to look into the details of the discoverability, the admissibility.
Why authoritative proof? I acknowledge some of our sister circuits have said that. Why is that the standard? Why is there something other than just like more likely than not? I mean, most standards in the civil context are sort of more likely than not. Right. Why do we require sort of effectively like clear and convincing evidence, or I don't know exactly what authoritative proof means, but why?
So while this court hasn't adopted authoritative proof or another standard, the district court used authoritative proof. Cartograf USA didn't challenge the application of that standard, so we're also using that standard. The way that authoritative proof is helpful to the district court is when a party is able to demonstrate authoritative proof. The examples used in the case law are judicial, legislative, executive declarations. So if you can show the district court, here is declarative evidence that the Mexican court is not going to accept this because a foreign proof exists, that makes it easy for the district court to say, okay, I can reject this discovery, I can reject this application. But absent that, the district court's not supposed to delve into the details of Mexican law. 1782 protects the district courts from having to do that. So if you don't...
But 1782 itself doesn't like say that, right? It just says you can't do it if there's any legally applicable privilege.
Correct. But the interpretation by many courts is... And
what I'm asking is why do we have this high bar for what's required to show what a legally applicable privilege is?
Well,
I mean, I'm not sure they've done it under any standard. I'm not talking about this specific case. I'm just curious why you think that's the right standard. Like, we have to figure out what the law is. We don't get to just accept your legal conclusions, right? We have to figure out what the law is. And so what I'm curious is why you think that's the right standard.
Other sister circuits use it. That's one of the most commonly applicable tests in this context. So we looked to that standard.
So is there any other standard other circuits have used besides this authoritative?
To my knowledge, none are coming to mind, Your Honor. Again, this was not contested by Cartograf, the application of that particular standard. But
If the standard applies, is it not met here because of the legal affidavit from the Cartograf's Mexican law firm? Is that the basis that the district court used?
That is correct. Cartograf...
Why was their opinion deficient?
So Cartograf USA submitted this declaration from a law firm, and it's deficient for several reasons. It doesn't meet this burden of authoritative proof borne by Cartograf USA. First, the last paragraph of the document is a disclaimer. The document says this is a preliminary legal opinion, and it says, and I'm quoting, by no means, this should not be used by no means as a definitive legal opinion to be used officially by any party in any way. So that right there shows that this is not any form of authoritative proof. It's a disclaimer. Don't use this document in any official way. Beyond even that, the document is vague and it is not conclusory. So with regard just to the civil proceedings, looking alone at that, this firm opined generally on principles of Mexican foreign self-incrimination laws in Mexico. There was no application to the facts of this case. And even just sticking with the criminal proceeding for which Cartograf had all of the information, presumably its expert had access to all of that information. There's no application of these foreign legal principles to the documents being sought in this case or the facts of this case.
Can we
So-
get back to the idea of limiting discovery or limiting the use of these materials to the civil proceeding? You stated earlier that your client would oppose that. I guess I'm perplexed as to why, if the use that you're seeking the information for is in the civil proceeding. It seems to me that although it wasn't discussed below, it would solve everyone's problem to have the subpoena response limited to the civil proceeding and not available for the criminal proceeding. And then everybody would get what they want, right?
Right, so we're not necessarily opposing it, but the question here is whether or not the district court abused its discretion in not granting a protective order. And it did not, because it wasn't requested, and from the district court's perspective, there was no reason to impose one. The district court considered these arguments. It found no bad faith. It found that the mere mention in a single sentence of the criminal proceedings did not warrant a special protection for Cartograf USA. So because this wasn't raised, the district court didn't abuse its discretion to just not sua sponte issuing a protective order beyond what it did. Again, its decision, its 26-page opinion was nuanced, and it provided protections with respect to the tax records. So the district court did not abuse its discretion by not issuing that protective order. And certain cases, such as accidental delight and in re Republic of Nigeria.
So does your client object if the court were to remand with instructions to modify the order to exempt the criminal proceedings?
If the court thinks that that is the best course of action, we would request that the court remand with an instruction to consider the issue of the protective order, since it hasn't been considered yet.
To do that, we'd have to find an error, right? We'd have to find the district court erred in failing to sua sponte enter this protective order. I mean, we don't remand without an error.
Then yes.
So is that now, yes, you would object, or no, you would not?
As I've stated, we do not think that it's necessary, but if the court considers that the best course of action, we're not objecting.
All right.
If there are no further questions, just want to say in sum, the Banorte Party Section 1782 application, it was proper and it was well-founded. The district court did not abuse its discretion in granting that application, and it did not abuse its discretion in denying Cartograf USA's motion to quash, and this appeal should be denied. Thank you.
All right, thank you very much. Mr. Cassidy, you have some rebuttal time.
Thank you, Your Honor.
So did you ask the district court to do a carve-out for the criminal proceeding the way you did for the tax records?
I don't believe that we specifically asked that question. We did argue it. We did argue that our argument was not necessarily the carve-out. Our argument was we need sufficient detail on this particular proceeding, which they know about. And I just want to be really clear on that issue. There is nothing in the record that Cartograf had information about this criminal proceeding. This is not like Mexico has LexisNexis and you can find these criminal complaints, which is one reason why Cartograf invoked both In re Newbrook Shipping Corp. And the In re Turk case. All we're asking for is sufficient detail to allow us to adequately defend our client, to allow us to adequately assert privilege. On the issue of privilege, it's very clear the judge acknowledged, there's a split in the circuits, but he acknowledged that there was a privilege under Mexican law, but he took the step of saying that the opinion itself that was provided by the Mexican experts did not apply the law to the facts. And our argument is, how could they when we don't know what the facts are? And what we're asking for is a cause number and a court where this complaint has been filed. That information we do not have. And that's precisely what we're asking for here. On one level, I somewhat agree with the panel. This is a relatively simple issue. One, because they're saying they're going to use these documents and they have referenced this criminal complaint, the court should demand a certain level of detail. That's to allow us to defend our client. That's to allow us to properly assert a privilege. So the Mexican opinion on privilege law, which attaches to corporations in Mexico, usually it doesn't here, was stated correctly. But he couldn't apply it to facts because we don't have the cause number. Now, it's possible if they had provided us with that information.
So did you object in the district court to the use of this authoritative proof standard?
No, I think we meet the standard, and we've detailed it in our briefing. All of the authoritative proof standard is simply this: you have to go to authoritative proof in Mexico and base your opinion on it. What the courts are trying to get away from is this idea of battle of experts, that it would be inappropriate for everyone to be having expert opinions on Mexican law and forcing a district court here in the United States to make that determination. We don't have that problem here because they never presented a different version of Mexican privilege law. The notes are never challenged. So the only thing in the record is our assertion of Mexican privilege with our experts out of Mexico who cannot apply it to facts that they don't know. I mean, there is a very simple explanation to this. All we are saying is that under the cases, both In re Newbrook Shipping and also In re Turk, there is a duty of good faith to provide details about a known criminal complaint. When Benota says this is ongoing, they are the ones who say that this is an ongoing proceeding. They have a duty of good faith to tell us the details of that case so we can properly defend our client. That fundamentally is the issue. If they had never said there was a criminal proceeding, this wouldn't be an issue. But the fact remains there is a criminal complaint. I will also say, and Your Honor, I fully agree with you. This issue of how the Mexican law procedure works in Mexico, I have a different opinion on that. And I have done work in both Brazil and Mexico on whether private citizens can pursue criminal complaints and participate in investigations in global South countries. But that issue is not in the record. It wasn't argued with the court. Instead, the fundamental issue is, should the district court require them to simply give us the details and information about the criminal complaint and how they're going to use these documents so we could, one, if we wanted to ask for a protective order, say, no, you can't use these documents. That would be getting around truth-gathering procedures in Mexico if you're allowed to take these documents and use them as part of a criminal complaint or proceeding in Mexico. I mean, it's basically the lack of detail that they know and will not provide that hinders our ability to adequately defend and assert privileges for our client. The Mexican opinion was found to not be authoritative, not because of what he said, but because it did not go to the facts of the case. But how can we apply it to facts that we don't know?
Well, I think that the opinion was found not to be authoritative because it was provided by a law firm and it was tentative and it was not provided by any judicial or executive or legislative body in Mexico.
The court specifically says that it is not going to adopt the opinion because it does not apply facts to the opinion itself. Is there an argument that authoritative law in Mexico would be stronger if it was a pronunciation of the Mexican Supreme Court or statutes? Yes, that is true. Our position, however, is that this particular legal opinion was based specifically on authoritative Mexican law, and it lays it out in the opinion. The fault that the district court found was it simply did not apply to the facts. And if there are no further questions, I'll cede my time.
Thank you very much.
Thank you.
We'll come down and greet counsel and then take a very brief recess.
The The Honorable Court will take a brief recess. Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
Please be seated. And we're now here argument in Baxter versus Becerra. Mr. Johnson.
Thank you, Judge Agee, and may it please the court. Tom Johnson and my colleague Brandon Moss appearing for Dr. Timothy Baxter. Your Honor, the Secretary erred in interpreting federal law to require that Dr. Baxter be excluded for 5 years from participation in any federal or state health care program based on his plea to a single strict liability misdemeanor offense. That is because under this court's case law, the text of the exclusion statute required a categorical approach to determine what past convictions are eligible for exclusion. That is fatal to the Secretary's position here, as the government has never argued it could prevail under a categorical approach. The government simply believes that it can apply a circumstance-specific approach to this statute, but that is wrong. Under this court's case law, like Keene...
If in a hypothetical world that we agreed with your argument, do you agree that it would require vacating and remanding in the agency? We couldn't address whether you satisfy the categorical approach or not, right?
No,
That's
right.
a question that would have to be sent back to the agency to do in the first instance.
Well, a couple responses to that, Your Honor. So we seek vacator. They don't come back and ask for remand without vacator. They, this court has never adopted the Allied signal test for that. So we think vacator is the appropriate remedy here. Now, we also think they've got a significant Chenery problem. It's another reason this court could not address that in the first instance. They've never argued that the categorical approach applies. They've never argued that the modified categorical approach applies. So if this court determines that the text of this statute determines it, the appropriate remedy would be to vacate the rule. Then, if the agency decided to initiate further proceedings, we'd have
Vacate
arguments
the
there.
rule.
Vacate the exclusion.
Right, right. Okay. And in that instance, the answer would then be maybe they could bring a separate enforcement proceeding. That's your position, is they have to bring a separate enforcement proceeding to proceed under the modified categorical approach.
Under their rules, they would have to notice a different exclusion, Your Honor. They would have to notice a different exclusion. Now,
No, they would notice the same exclusion. They just would say you're a categorical match.
that's fine, Your Honor. So I don't want to quibble with you. What I want to reserve here for my client is there are arguments under their rules that it would be too late for them to proceed. We would have arguments against that. But yes, for purposes of this proceeding, you would vacate, and then if they wanted to continue to pursue relief against my client, they'd have to start a new proceeding. And that's the appropriate remedy here, Your Honor. I mean, to put a fine point on it, if you look at Government Brief 37, the government...
I didn't mean to distract you with the remedy. You probably want to focus on the first part. I just wanted to understand what your view was on the remedy. The why categorical in theory applies is probably where you want to focus. I didn't mean to get you totally distracted.
I'm happy to talk about what would happen if this court vacates the rule, Your Honor. We obviously think that's dictated here by the text of the statute. And this court has said in Sims and other cases, that is the inquiry here. It's the text of the statute. So if you look at Keene, for example, the use of the terms convicted and offense, criminal offense in the statute are indicators of the categorical approach. If you look at Hardin, Your Honor, and they admit this, they say in Government Brief 37, that the Hardin case involves the same term related to that appears in this statute. And as this court said, that indicates a categorical approach and then some. That's a modified categorical approach. Again, Judge Richardson, they don't make a modified categorical approach argument. That would be
But
way
the difference
under
with
Chenery.
like Hardin and Pugin are that the relating to is followed by a generic offense, right? So like Pugin's the one that I just happen to know better than Hardin. But relating to obstruction of justice in a list of other offenses that are relating to offenses, like criminal offenses, generally statutory sections in A43. And so that seems like a straightforward understanding. But when we look at the other cases, when relating to is followed instead by conduct rather than a generic offense, it seems like we would look at specific circumstances. So if I don't think that Boogan and Hardin, when relating to, is followed by an offense description, like help you, can you address when we've got relating to followed by a set of conduct?
Well, Your Honor, I don't know that the test should be relating to followed by a set of conduct. So.
That wasn't a test. That was just a description of what we have here.
Yes,
That was my description of what we have here.
I understand that, Your Honor. So let me address that. So they argue, this is the move that they make, that there needs to be a generic offense as part of this statutory clause. But there's several cases, Your Honor, in which this court has not required.
I'm not sure who they is, and I'm not sure what that.
Well, I can.
So maybe, okay,
Sorry.
I'll let you finish. I'm not sure I'm following you, but go ahead.
Okay, so the Secretary makes a variant of the argument you just made, Your Honor, which is that this statute, in order to apply a categorical approach, requires that you have.
I understand they're making a slightly different argument. My point is not that it requires it. It's not a command, right? But we're trying to read the language, and we know from all of the Supreme Court cases that the idea of offense can be case specific or it can be categorical. And so we're trying to figure out which it is.
I understand.
Right? And so these are textual clues. They're not commands. I understand you want to call them commands. I don't think that's what they're arguing. It's certainly not what I'm arguing. But they're textual clues that we look to, right? And the cases that you started relying on, I was just responding to your argument, were cases where relating to is followed by an offense, right? Obstruction of justice, right? Which is unlike what we have here. And the textual clue in this particular instance seems to point in a different direction, right? And so what I'm asking you is, why should I not think about that textual clue in the way that I've described it, as opposed to analogizing it to cases like Pugin or Hardin?
Right, Your Honor. So I think the key difference there, as you said, is the fact that this doesn't have some generic hornbook offense like burglary or arson. I don't know that I can point to a statute that says related to and then doesn't have a generic offense, but the overwhelming authority here says that it doesn't matter that there's no generic offense. So the government made a similar argument to this court in Prudencio. That involved the phrase crime of moral turpitude. The government there said, well, there's no such hornbook crime of moral turpitude, that must mean circumstance-specific approach. And this court said, no, actually, if you were to apply the circumstance-specific approach in such a case where all we see is the word crime or offense and we don't have any other qualifier, then that would encourage the government to go through the factual record to determine any factual connection to the offense. And they said this is a unified phrase.
Hold up, counsel.
Yes, Your Honor.
The phrase here is related to the delivery of an item or service under Medicare or a state health care plan. What's the generic offense that you would derive from that?
So I don't think we need to identify a generic offense, Your Honor. Again, there's no generic crime of moral turpitude in the Nijuan case, for example, and the Kawashima case. The phrase is fraud or deceit. There's no generic crime of deceit. In this court and the Supreme Court's
Right, but how is that phrase not fact-specific?
It's not fact-specific because I think just like in Prudencio, it is what this court called a unified phrase. It describes the categories of crimes that are eligible for exclusion.
All right.
It's
so
not a phrase that, I'm sorry, Your Honor.
What are the categories?
Okay, so it would need to be a crime that had as an element, if we're talking about the pure categorical approach, a crime that has as an element the delivery of an item or service under a federal or state healthcare program. Now, because...
So what example do you have of that?
So in our reply brief, Your Honor, we have examples of state Medicaid criminal statutes that relate to, for example, there's a Texas law in there, but these are representative of laws throughout the country, in which a patient falsifies an application for a drug. We have, there are cases where a provider falsifies patient information, things like that in which we know that there's an actual beneficiary under the statute, in which we know there's actually been an application for items or services. And this is where related to does work, Your Honor, because if it's...
How does that tie back to making some sort of a generic crime for categorical purposes? purposes.
Well, this is where I want to impress on you, Your Honor, is that I don't believe a generic crime is required. So if you look, for example, at the residual clause cases, this court's case in Sims, the Supreme Court's case in Johnson, that involved a statute that said substantial risk of harm. That is not referring to a generic offense.
That went out on
But
vagueness grounds, among others.
well, yes, Your Honor, and precisely because the court starts its analysis, both this court in Sims and the Supreme Court, by saying a categorical approach applies. And then starting from that premise, it said it was
But
unconstitutional.
it does that by looking at textual clues, right? And so what I guess I'm sort of going back to, and maybe you've answered it to the extent you can, but tell me why when we have relating to followed by conduct, a description of conduct, what is the clue there? I don't need cases, but just like conceptually, why would I think that refers to some sort of categorical inquiry? That doesn't seem like that works. I understand the clues the court relies on in Sims and the Supreme Court in Davis, but like when I look at those clues, they look different here. And so I'm just trying to understand from a logical perspective why you think that relating to a set of conduct is categorical in some logical sense.
Sure, Your Honor. So I guess where I'd push back on your question is that I do not think that what follows related to refers to conduct. I think it's essentially an element of an offense. And Your Honor, this is very common.
I'm sorry, say it, can you just, because I think maybe this is what I'm trying to get at,
Yes,
help me understand.
absolutely. It's an element of offense. So if you just think, Your Honor, think about federal criminal statutes in which the interstate commerce of drugs or prohibited articles or things like that.
And what is
are
the
part
element of the offense that you think it is? The delivery of an item or service?
That is what I would call, just like this court in Prudencio, it's a unified phrase, just like in Prudencio. Okay, we're talking about moral.
And the unified phrase in Prudencia is crime of moral turpitude, and you think the unified phrase here is criminal offense related to the delivery of an item or service under Medicare or any state health care? That's the unified phrase?
That's correct, Your Honor. That's our position. And it follows not just from what I said, which I think this sounds in legal arguments. We have these interstate commerce clause in federal statutes, federal criminal statutes all the time. But also it's the absence of indicators that the courts have said. This is not a case, for example, where, like in Keene, there's a reference to present conduct, present tense conduct, like the word assaults. This court has also said in cases like Mathis that if the statute said, Your Honor, committed by the defendant, then that is a textual indicator that the statute is looking to conduct. And, Your Honor, I think the policies here are important. It's not that we're diverging from the text, but this is how we're giving full effect to the text that Congress had here. What this court said in Prudencio, the whole purpose behind the categorical approach.
If we don't give effect to this particular circumstances test, that basically the statute has no purpose.
They say that, Your Honor. I mean, basically they raise that by way of a surplusage canon. I mean, we think that the text here, and I agree with you, Your Honor, it doesn't need to be compelled. We're just looking at clues and indicators. We think that the indicators here indicate the categorical approach. They come back with this surplusage canon. I don't think that, us representing the citizen, before the government can exclude us for 5 years, needs to come up with a laundry list of how the government could permissibly interpret this statute or prosecute this statute. But we do come up with some state-specific crimes that could be eligible.
But the state-specific ones that you give us, I confess, there were several of them, but they look to me like they involve not delivery, but receipt, right? So these are the customer side. It looked like the statutes, maybe you can correct me if I'm wrong, right? And so that's not a criminal offense relating to delivery, that's a criminal offense relating to receipt?
So some of them are provider side, some of them are applicant side. But what we say, Your Honor, is that we're happy to concede if we're in modified categorical territory under Hardin, there does not need to be an exact match between the underlying, the predicate offense and the text of the federal statute. All that matters is that the state offense is narrower. And so if you have unlawful receipt of an item, then presumably there was delivery.
That's not narrower than delivery, right? I mean, those are different things. Like receipt and delivery aren't like subsets, right? They're just distinct acts.
Well, I guess I would say, Your Honor, that, again, with respect to the specific examples we found, we don't know that it's our burden to find them, but with respect.
No, I just want to understand whether the examples you've provided are helpful, right? That's all I'm asking. You don't have to provide them, I acknowledge
I
that.
think we would have a much harder case if the government came in with those examples, because then I think that if you're in a case in which a provider is unlawfully billing the Medicare program, if an applicant is unlawfully seeking access to a drug, I think there's a much closer correlation there to think an actual delivery occurred. So, I mean, those are examples where I think under a modified categorical approach where, this court has said the match does not need to be exact, those are possible candidates. But I would put it to the government to determine whether there might be other possible candidates.
The
But
DC Circuit seems to go the other way from what you're arguing in this Friedman case, and that's a statute that would on its face appear to be more amenable to your argument because following the related to provision, they do include some generic terms, fraud, theft, embezzlement, etc., before they get to the in connection with the delivery of a healthcare item. And the DC Circuit still used the circumstance-specific approach there.
it did, Your Honor, and two responses to that. In the specific provision of the exclusion statute at issue in Friedman, the statute also said other financial misconduct that could be an indication that the court should look there more to conduct rather than the elements of the offense. But even putting that aside, Your Honor, this court's case law is in tension with Friedman. The court in Friedman said that convicted is an indicator of the circumstance approach. That's not the case under this court's case law. Under Keene, this court said convicted means categorical approach. The court in Friedman said related to indicates a circumstance-specific approach. That's not this court's case law. In Hardin, this court said modified categorical approach. And so I don't think this court can start from a premise with Friedman. I think it needs to look at its case law. And putting a final point on, Judge Richardson, how do we look at this clause? And again, giving full effect to what Congress said about conviction, what the categorical approach is designed to do is to limit the imposition by a subsequent agency or court. May I just finish my answer, Your Honor?
Right ahead.
Yeah. Limit, use by a subsequent agency or court of placing new impediments on a prior conviction by making sure that the elements of that crime were either found to be true by a jury beyond a reasonable doubt or admitted by the defendant. When you have conviction related to, and you interpret that as circumstance specific, you're encouraging a future fact finder to delve through that criminal record and make new findings and impose new penalties on the criminal defendant. That's why the court should apply that approach here.
All right, thank you, Mr. Johnson. You've got some rebuttal time. Ms. Levinson.
Thank you, Your Honors, and may it please the Court. Rebecca Levinson, Assistant United States Attorney, here with my colleague John Lucier, also an Assistant United States Attorney, on behalf of Secretary Becerra and Inspector General Grimm. Your Honor, I will start with the categorical versus circumstance-specific approach, since that was the substance of my colleague's argument. And we would note that, as the court has already observed in this argument, the crux of our reading of the statute here and the arguments in our brief is that, read as a whole, the provision at issue here is one that is focused on the conduct that related to the delivery of an item or service under Medicare or a state health program, certainly indicates conduct, and the Friedman Court agreed with that. It observed that a very similar provision of the permissive exclusion statute relating to the delivery of a healthcare item or service also indicated conduct. To address what Mr. Baxter's counsel stated earlier, the words on which he relies do not take that second part of the statutory provision into account. He relies on the word convicted, but the Supreme Court in Hayes applied circumstance-specific reading to a provision that had convicted in it. This court in Prudencio noted that convicted's meaning can change, as the Supreme Court and this court have also observed with respect to the word offense. We certainly agree with Judge Richardson's explanation of the difference between relating to in this case and relating to elsewhere. And I would say that the cases that plaintiff's counsel identifies that do not use a generic offense do, as our brief notes, point to describe crimes that have as an element, for example, in Prudencio, have as an element the essential elements of a crime involving moral turpitude. And not only that, but in that case, this court indicated that moral turpitude is a longstanding term of art that had been interpreted by this court for over a century. We don't have that here. And as we note in our brief, we have not been able to identify a federal criminal offense, either the government or Dr. Baxter, that would categorically fall under this provision, which would render the under subchapter 18, the part referring to Medicare, wholly surplusage. We would certainly agree with, it is our position that plaintiff's reading would render this provision essentially meaningless.
The under subchapter refers to the offense. I took that to refer to the delivery of item or service. So it could be a state offense. It doesn't have to be a federal offense, right? It's a state offense for doing it or a federal offense. Your point is there are no federal offenses. Your colleague responds and says, well, what about these state offenses?
Yes, Your Honor.
It doesn't read it out just because there are no federal offenses. I mean, I'm not sure that there are state offenses either. He and I had that colleague. But why does it matter if there are no federal offenses?
Your Honor, the state offenses that Dr. Baxter's counsel cited to relate to state health programs. They don't identify Medicare, and I would note that even those 4 statutes, not all of them would likely categorically apply. The Maryland statute is for knowing possession of somebody's pharmaceutical benefit card, which certainly strikes me as a bit far, could strike me as a bit far afield. As the Supreme Court in Nijuan and in Hayes noted, with statutes that offered more state possible routes for state offenses, and even in Nijuan, 1 federal offense, that is not enough. Four statutes are not enough to give effect to this provision, which I would note is the first line in a congressional statute about mandatory exclusion, and one that is most closely connected to the programs that exclusion is meant to protect. Moving on to plaintiff's new due process arguments, we would simply note...
Before you go to the due process arguments, so why is this case not like Davis, right? So Davis is maybe it's not the most recent, I guess we've had others, but it's the most recent, actual engagement with this question of, how do we understand and interpret a statute? And so if you were walking through Davis, why is your argument consistent with it?
Oh, pardon, Your Honor. So Section 924C, which was interpreted in Davis, defines crime of violence, which is the operative term that's being interpreted, as an offense that is a felony and has as an element, or B, that by its nature involves. So both of those provisions, and I'll say that that Section B was at issue in Davis are classic indicators of the categorical approach, which is simply not apparent in this statute, which is, I will say, not of a kind with the gun statutes and immigration statutes that the categorical approach is kind of typically associated with. And then the court also noted in Davis that the government had long held the position that this provision was to be read categorically. That's not the case here. HHS has a long history of taking the circumstance-specific approach to these statutes and has done so for decades. So I think on those bases, I think Davis is easily distinguishable, Your Honor.
What about the sort of consistent usage argument? If I read through A7A, it does seem, I get they're different places, but the offense relating to, sometimes it's followed by what are, I guess, arguably or generic offenses, and sometimes it's followed by conduct. Does the consistent usage give you concern there?
Your Honor, well, with respect to consistent usage, Friedman analyzed relating to, which was followed by a list of generic crimes, and ultimately decided that relating to is used consistently throughout the statute to mandate a circumstance-specific approach. So following Friedman, I don't think that the consistent use statute would pose a problem for our argument. It would.
So you think it's a circumstance-specific, like all the way down?
Yes, Your Honor, unless there's some specific indicator of the categorical approach I haven't noticed. I certainly have not noticed one in A1. If Your Honors will permit, I will move quickly to the two other arguments in our briefs. First, that having applied the circumstances-specific approach, HHS's opinion or decision, as the district court rightly held, is both supported by substantial evidence and is neither arbitrary nor capricious. Dr. Baxter pled guilty for responsibility for statements that misstated the pediatric exposure rates for a product that his company put into commerce, and did so with, and those statements were made with the purpose of expanding Medicare access to them. He pled guilty specifically to causing the introduction and delivery for introduction into interstate commerce of a misbranded drug. That's at JA 346 is the count, and JA 349 is the admission. We would also note that plaintiff, with respect to his due process arguments, did not seek summary judgment on that ground below, and to the extent that it is preserved notwithstanding, plaintiff has not identified a due process standard that supports his argument that strict liability can't be imposed here. Indeed, Friedman goes completely the opposite way, address this issue head on. And plaintiff does not meet the standard under any due process framework. He doesn't attempt to meet the shocks the conscience standard, nor could he. And any challenge to a legislative enactment would have to establish a fundamental and deeply rooted interest, which Dr. Baxter certainly has not established. And his right, as narrowly defined, is continued participation in Medicare and Medicaid. That certainly can't be. That certainly is not a deeply rooted right. And therefore, even a closer look at his due process arguments, his arguments fail. Unless this court has any further questions, we would respectfully ask that the district court.
I guess I had a question about forfeiture of the standalone due process claim. Is it your argument that that claim has been forfeited?
Yes, Your Honor.
All right, thank you very much.
Thank you very much, Your Honors.
All right, Mr. Johnson, you've got some rebuttal time.
Thank you, Your Honor. I'll just make a couple of quick points. I don't know that we got on the initial presentation into the two key cases that counsel cited in support of their category, in support of their circumstance-specific approach, which, by the way, is relatively rare. I mean, if you look at this court's case law, if you look at the cases that have considered this sort of language, most of them do apply a categorical approach. They cite the two cases, Nijuan and Hayes. Both of those cases included a detailed qualifier that instructed the court to consider a factual circumstance. It was that certain applications of this crime were either in or out. In one, it was whether there was damage to the victim exceeding $10,000, and in the other, it's whether the crime was committed by a close family member, a spouse, and then there are a laundry list of other family members. So that is not the kind of language that we have here. And in both of those cases, that qualifier followed the description of the offense. In fact, in a follow-on case, the Supreme Court said that even though that $10,000 monetary threshold required a circumstance-specific approach, that the crimes, fraud or deceit, which again, deceit, not a generic offense, that part of the statute required a that part of the statute required a categorical approach. Just a note on due process and sort of how it plays into our argument. So Judge Berner, we did preserve this as a separate count in our complaint. We argued it as part of our major questions argument in the district court. It was passed upon by the district court because the district court found there is no due process violation here. In footnote 17, the district court also rejected our constitutional avoidance argument on the basis that, in its view, there was nothing to avoid. But I want to explain why I think it's important here, and I'll focus on the constitutional avoidance part, which, again, explicitly preserved and passed upon by the district court. In Morissette and Staples, the Supreme Court has said that the reason why it upheld RCO strict liability for certain offenses was in part because the penalties were relatively small. So $500 civil penalty or something like that. In Morissette and Staples, the court interpreted other federal statutes that would have imposed jail time on the criminal defendant as not permitting strict liability offense because that would be too far. So I don't think this court needs to create new case law in terms of where exactly that line is, but I think this court should apply the same constitutional avoidance canon that the Supreme Court did in Morissette and Staples. If there's any doubt in the court's mind as to whether this provision requires a categorical approach, then this canon of avoidance should weigh in favor of applying it. Thank you, Your Honor.
All right, thank you very much, Mr. Johnson. We appreciate the argument of both counsel in this case, and we'll come down and greet counsel and move on to our last case. All right, please be seated. All right, our last case today is Holmes versus Elephant Insurance Company. Ms. Koff, did I pronounce that correctly?
Baxter, Your
All right, thank you. We're glad to hear from you.
Good morning. May it please the court, Kate Baxter on behalf of plaintiffs Christopher Holmes, Trinity Bias, Jamie Cardenas, and Robert Shaw, and the class that they seek to represent. As the 11th Circuit recently held in Green Cooper versus Brinker, the presence of information on the dark web, as pleaded by 2 of the 4 plaintiffs in this litigation, provides sufficient evidence of both a present injury and a substantial risk of future injury and the future misuse of personal information associated with their names and driver's license, sufficient to find a concrete injury sufficient to establish Article 3 standing. In this case, because the Fourth Circuit's holdings in Hutton, Beck, and the statutory cases in TransUnion and since then counsel a reversal of the district court's decision, the plaintiffs ask that this court find that they have Article 3 standing. In this case, there are 3 or possibly 4 different lines of analysis that this court can and should pursue to analyze Article 3 standing. And that's sort of in 2 subsets, which is standing for damages for a common law claim and standing for injunctive relief for a common law claim, and then standing for damages and injunctive relief for statutory claims. The plaintiffs in this litigation pleaded 8 counts. It's 4 common law claims and 4 statutory standing claims. And the district court
Don't we
here—
have to find standing for each claim separately?
Yeah, the Fourth Circuit case law is pretty clear that standing is done on a claim-by-claim basis, and that also that the standard for how it is that requirement is met changes throughout the case and matches the requirement, the evidentiary requirements from the beginning to the end of the case, right? So this case is at a motion to dismiss. So like in Hutton, it's just a question of whether we have plausibly pleaded facts sufficient to support an Article 3 standing
Right,
claim.
but we have to find standing for each. It's
Yes,
not
that's
separate
correct.
theories. It's that we have to actually find standing for each separate claim.
Yes, that's correct. And that it's possible, I suppose, that this court could conclude that we have standing for some claims and not others. When other courts, especially courts of appeal, have analyzed this, it has been most common that there's a distinction between whether they're standing for a damages claim versus an injunctive relief claim. But in this case, it could also be the case that there is statutory standing for the DPPA claim under Gary, even if there's not, our common law standing under the traditional analysis for the common law claims.
So why don't you tell us what your pleadings say that tell us that you have a present injury or a future imminent injury?
Sure. Obviously, it's injury in fact traceable to the defendant's conduct, redressable by a favorable decision. Injury in fact, I think, is the largest portion of this discussion. And we have 4 named plaintiffs. 2 of them who were all subject to a data breach or a data disclosure at Elephant Insurance Company.
Why don't you take Mr. Cardenas first? He's one of them that has his driver's license, he says, on the dark web.
Yes.
Tell us about him.
Yeah, so Mr. Cardenas received notice in June of 2022 from Elephant saying that his name and his driver's license number were compromised in the attack. He thereafter received notice that that particular information, his name and his driver's license number, were on the dark web. He thereafter spent time dealing with the fallout of that. So making phone calls, securing his information, monitoring his credit. He continues to do that and continues to do that going forward.
How does an individual's driver's license number, not the full driver's license, right? It was just the
Yes.
driver's license number without the other information on the driver's license. How does that put an individual at risk of identity theft?
So it was the name and the driver's license number. So under federal law, a driver's license number in conjunction with the name is protected information because that information can be used both alone and when aggregated with other information in order to commit identity theft. And we say that's true in a number of circumstances. First, that the presence of the information on the dark web by itself constitutes identity theft. It has been taken by a third-party hacker. It is posted for sale on an encrypted criminal forum and is available for that.
This is, in your view, a present injury.
Yes. The presence of the information on the dark web in and of itself is a present injury and a present experience of identity theft.
Let's take a slightly different factual setting. So instead of using computer access, let's say that the applicant and the insurance agent are going to go old school. So he goes and he fills out everything on a written form. The agent has it. He's going to process it. The agent goes home for the night. Somebody breaks into the insurance agency and they steal that off the agent's desk. So does that lead to a present injury?
I think it would depend on the circumstances. Well, and then posts it on the dark web?
Sure.
Okay. So I think yes, but it would depend somewhat on the circumstances of the theft. So
They take a sledgehammer and knock out the window and break in.
I think the more violent the intrusion, the less likely that there can be negligence associated with the action on the part of the agent. So the facts that I would want to know are there.
Why do you care whether it was negligence?
Well,
You sort of accept that it has to be negligence. Why?
No.
Why?
In fairness, no. Our claim is
I didn't
more.
think you wanted to do that, but so you can do them in alternatives, like if negligence is required, then we do that. But tell me why you think that negligence is not required?
So, what I was trying to speak to was when you talk about data breaches or data disclosures, when you're talking about computerized information, one of the ways that courts often analyze them is to think about the ways in which the information is being targeted by outside sources and how much that's connected to an increased likelihood of harm. So
we're not talking about a likelihood of harm, right? I took Judge Agee's question to be out whether it's a present. He asked, is it a present injury?
Then yes.
Not an imminent injury,
Yes.
right? The question he asked was, is it a present injury?
Yes.
And your response is, well, it depends on negligence.
No.
And that's what I'm trying to understand is, why do you go there? Why do you think that the negligence of the agent, right? Did he lock his door or whatever it is that you want to describe? Why do you think that matters when we're asking the question in TransUnion about what the nature of the harm is?
I don't think it matters for injury in fact, and I think that I anticipated the question of traceability instead, which is, I think that it constitutes a present injury. I think it constitutes both a present injury and an increased risk of future harm, right? So I think there is both the present injury that the information has been taken and that and in our scenario, if it's on the dark web, that is a present injury, a present experience of identity fraud on the part of the person whose information was compromised. And then it is also an increased risk of future harm to that person.
And so I take that argument to be that there need not, in order to draw the analogy to the public disclosure of private information, there need not be any actual disclosure, right? That element of that common law tort doesn't go to the nature of the injury at all. And so whether it's intentional, negligent, or unforeseeable, that the element of disclosure in that common law tort is not a relevant inquiry for determining the nature of the injury, and therefore, doesn't matter under TransUnion. Is that the argument you're making, or am I making a different argument?
Well, I think if this court concluded that element wasn't necessary, that we would be fine with that. That has
Sure, you'd
not.
be fine with it, but that's not what-
that is not my experience of the case law. I think the case law says, and this is in the
understand
case.
that too.
Yeah, I think
I'm
that
asking a
this is
different
only in the case of statutory claims, right? Because I don't think we have to have a common law analog for a negligence claim.
No, we're talking about the
Yeah,
statutory.
so, but for a DPPA claim,
Part of your argument is this is we looked at TransUnion.
Yes.
TransUnion tells us to make an analogy.
Yes.
Right? The analogy that you've put forward is
Right.
public disclosure of private information.
Yep.
That requires three things effectively: publicity, private information, and disclosure. Right? Those are basically the three things.
Yes. I think, you have to,
The private information is the invasion
Invasion,
piece,
right.
right? So-
Yes.
So those are the three pieces.
Yep.
Right? I understand the first two arguments, but your colleague on the other side said, because the information was stolen, or a version of your colleague's argument, and the premise, I take it, of Judge Agee's question, is that there's no indication here of voluntary disclosure, which would be required under that tort, and so you don't have an analogy,
so.
right? Because it was stolen.
So I think that's a question of the pleading of the claim, because we do make a claim that the information was voluntarily disclosed.
So I understand the fill box, but stay with this argument. That's an alternative argument, right? So stay with this argument for a minute. I get that's a different argument. Maybe I'm not making myself clear enough, and I'll let you just go on if you want to. Do you believe, in order to draw an analogy to the public disclosure of private information, that you need to show all three things, that there's publicity, that it's private information, and that the defendant disclosed it?
I believe that we need to plead that the information was either intentionally or negligently disclosed. I don't believe that it has to be voluntary, because I don't think that that's part of that claim. That is an element of a DPPA
Intentional
claim.
or negligent, but it has to be one of the two.
Right.
If they are not negligent, in the sledgehammer example, you agree that that's not an analogy to that common law tort? I didn't understand that to be your argument before, but if that's all you're arguing, that's fine.
I guess what I'm saying is, I think that there is an element of disclosure. I think that we have to plead all the elements of the common law claim. I think the case law is very clear that that there can be a very large difference in degree or rather than kind, right? That we don't need to plead, it doesn't need to have constituted a public disclosure, a private flax claim at common law. We don't have to meet the standard for the claim. But you do have to be able to make an analogy to all the parts of the claim, right? And in this situation, we do make an analogy to all of the parts of the claim. We say that the way that that Elephant designed and configured its online system constituted a disclosure on their part, right? That's paragraphs 4, 5, and 153 of the complaint. And so that's sufficient.
What you say those paragraphs say
Sure.
makes this a disclosure on Elephant's part?
Yes. So we allege that the way that in the spring of 2021 and going forward, there was a concentrated and online and configured online attack on insurance companies and their agent and consumer platforms for insurance-based information, and specifically in which hackers targeted driver's license numbers and names in order to disclose that information, and that Elephant configured its online quoting platform, either for agents or consumer facing, in such a manner that disclosed that information to third parties in a voluntary fashion. That's paragraphs 4, 5, and 153 to 155 of the complaint.
So is that 4 and 5 amounts to an argument of negligence?
I think our argument is that it is a statutory violation of the DPPA, but also that it is in fact negligent.
Yeah, you have to have knowing disclosure to come
Yes.
under the DPPA. So your argument, at least for the statutory part, is that this is the equivalent of an intentional disclosure, a knowing and intentional disclosure?
Well, it's a voluntary disclosure. The standard isn't, the standard for DPPA claims, and I will say, like, this is whether or not we prove a claim, like on a 12B6 level, rather than whether we have standing for that claim, but you don't have to, knowing disclosure does not mean that you have to, it's a general intent question, not a specific intent question, but yeah, at least 2 district courts have allowed claims to survive in exactly this scenario.
So you started out by saying you needed to establish standing, by conceding you need to establish standing for each separate claim, and one of your claims is for injunctive relief. So I understand you've made an argument that there's been a breach and that your clients have suffered past damage. What's the argument for risk of a future data breach?
Sure. My time has expired. Do you want me to answer that question? Okay. Yes. So we have 2 different arguments about injunctive relief. The first is that Elephant continues to maintain the private information that it had before and has not done anything to ameliorate those systems. So it is at a heightened risk of future data breaches. And then second, that the structural configuration of the system, of the computer systems that they have, makes it so that the disclosure of that information is also continues to be the case because they have not changed anything about the way that they configure those systems. Thank you.
All right, thank you. You have some rebuttal time. Mr. Is it Monagle?
Yes.
All right, we'll hear from you.
Thank you, Your Honor. Thank you, Your Honors. Good morning, and may it please the Court, James Monagle of Mullen Coughlin, here for Elephant Insurance Company. I'd like to begin by discussing the Ninth Circuit's recent Nobler opinion, which Elephant brought to this Court's attention as supplemental authority, because I think it will provide some background for some of the questions that just occurred. As the District Court noted in its order here, the Court need not accept as true allegations unless they have a sufficient factual basis to render them plausible. And as the Supreme Court instructs in Iqbal, in assessing plausibility, this Court must draw on its judicial experience and common sense. So here the Court's being asked to find it plausible that the Elephant breach was based on the exploitation of an auto-populating insurance quote tool. But this action is based on plaintiff's receipt of a data breach notification letter. And unlike other DPPA cases involving data breach notices, Elephant's notification letter makes no mention of any auto-quote tool being exploited. And in fact, nowhere in the complaint do plaintiffs allege that they visited Elephant's website or witnessed the use of any such auto-quote tool at any time, either during or after the incident. And that's noteworthy because there's no factual support for plaintiffs to seek injunctive relief based upon the alleged continuing use of such a tool. Instead, the plaintiffs argue that it's a fair inference to conclude that such a tool was used due to 2 alleged facts. One is a prior wave of incidents that were targeting other insureds' auto-quote tools. However, those incidents are alleged to have occurred more than a year before Elephant's incident. The plaintiffs allege at paragraphs 3 and 47 that all in 2001, there was a series of breaches that happened of this tool, and that on February 16th, 2021, the NYDFS reported that it began receiving reports as early as December 2020 that this tool was being exploited. The plaintiffs allege that Elephant was on notice of this wave in 2021 and as a sophisticated insurance company, but yet Elephant's breach didn't occur until more than a year later on March 26, 2022. Therefore, the Court does not have to accept plaintiffs' conjecture that there was even a tool used here that would make some kind of voluntary disclosure of plaintiff's information. The other allegations that plaintiffs rely on to argue that this theory is plausible is that plaintiff Holmes claims not to have had any direct contact with Elephant, but Elephant could have received his information as part of providing a quote, other than through the fraudulent use of an auto quote tool, such as if a broker sought a quote from Elephant, or if he used one of many ubiquitous online multi-quote marketplaces such as selectquote.com. Again, in that case, Nobler, the Ninth Circuit also found it not plausible that the plaintiffs concluded that of the different types of information here, name, driver's license, or date of birth, by the way, you had to have some of those components already, the threat actor would have, to use and manipulate the auto-populate tool impersonating one of the plaintiffs, any of those particular components was involved is speculation. What they said was, aside from the factual allegations pulled from the notice, plaintiffs provide no additional allegations that might provide a credible basis to conclude that the plaintiff's driver's license were indeed taken. Plaintiff's conclusory allegations were also rejected in this
Counsel,
regard.
Your letter to the plaintiffs said there was a breach. So does it really matter how the breach took place, that you've conceded that there was a breach?
It does, Your Honor, if we're going to get into later the analogs to torts, which is what Judge Richardson was focusing on in terms of does there need to be an analog here? And I'm happy to skip ahead to that particular argument. And the answer is yes, there does need to be all of those elements, and I believe that...
So help me understand why that is. So when I read, let me just tell you how I read TransUnion and tell me why I'm reading it wrong. TransUnion tells me to focus on the type of the harm. And then it looks at elements that affect the type of harm, and like publication there. And without that publication, there is no type of harm. But when it looks at elements that address the degree of harm, right, like falsity, it's willing to relax those. And I guess the challenge I'm having is when I look at the issue of the element of disclosure for this tort, it doesn't affect the harm to the plaintiff at all. The plaintiff is in the same boat if somebody, if Judge Agee has my private information in his office and it's stolen, or Judge Agee sends it out, right? The harm to me is the same either way. So whether Judge Agee intentionally, negligently, or without either of those, my information got out, the harm, which TransUnion tells me to look at, the type of harm is the same. So why don't I just disregard that altogether and not care one bit whether it was intentional or negligent or neither of the above?
Well, this court is no stranger to analyzing TransUnion in terms of these harm analogs. O'Leary versus Trusted ID, Fernandez versus Rentgrow, Hensley versus City of Charlotte. These are recent cases in which these were analyzed, and the real question is how far do you stretch the standards to still fall within that close relationship?
But I'm asking a more fundamental premise, right? Is that why do we care about the elements that don't go to the nature of the harm at all? Right? So I understand the stretch argument, and maybe that's a version of what I'm saying, but the disclosure doesn't go to the nature of the harm at all. It might go to who is responsible for the harm, right? Is it the thief or is it Judge Agee? I get that. But it doesn't affect the harm to me. The public now knows my private information. And so I am harmed in the same way, no matter whether Judge Agee was blameless or did it intentionally.
Well, respectfully, Your Honor, I think it does matter who perpetrates the harm, because otherwise you do fall afoul of having this be traceable to traditionally recognized torts.
Totally get that, and that's a traceability question. But for injury in fact, I take, since you move away from it, you agree for injury in fact purposes, it doesn't matter whether he disclosed it or not. It only addresses traceability, not TransUnion's harm.
I actually don't, Your Honor. I believe that, for example, in Bonac, where they found that there could be a harm there that's sufficiently analogous, and they cited the public disclosure of private facts, I think that was wrong because that was a breach where somebody invaded those systems and took the data, and I don't believe that there was a disclosure there at all. And that's one of the, I
understand you think it's wrong, but what I'm trying to understand is TransUnion tells me to ask the question.
Right.
What is the nature of the harm? Right. Is the harm analogous to the harm from a common law offense? Not whether the cause of action is analogous to the common law cause of action, but whether the harm is analogous to the harm. And you're asking me to think about something other than the harm.
Well, I'm not, Your Honor. I believe what you're trying to do is draw an analogy here to the public exposure of private facts. And for the court to find that to be plausibly pled, it would first have to find that Elephant exposed plaintiff's information through an auto-populate tool, which again, I
Nope,
challenge.
doesn't have to show that at all. My theory is it doesn't have to show that at all, right? And so,
Well,
you can respond differently, but what I'm trying to say is, help me understand why you think that goes to the nature of the harm as opposed to who the responsible party is. And we can talk about traceability if you like. That's an alternative argument, right? But as far as the nature of the harm, it doesn't seem to change whether Judge Agee is blameless or responsible.
Well, if you think that it still bears a close relationship, even though you're eliminating an element essentially here, which is, publication or disclosure, then you'd still have to find that harm is highly offensive, Your Honor. And here, driver's license numbers have been found multiple times not to meet that standard. So if the court allows, I'd like to address some of the standards that are in play here.
Can you start by addressing TransUnion's reference to the Supreme Court's decision in Davis, right? So when it talks about the disclosure of private information, the example TransUnion gives us is Davis, which is a candidate's total expenditures, which frankly doesn't seem very private to me. To be totally fair, that wouldn't have been what I thought was private. And yet that's the example that the Supreme Court gives us. What do I do with Davis?
Well, I think Davis is more of an example of that things could be intangible harms so long as they're recognized as creating standing. In that situation, it was complicated, Your Honor. Someone could have been essentially prosecuted by a regulator for not making past disclosures, and that
But the disclosure that was allegedly private, right, was the total personal expenditure in a campaign. I mean, this isn't like where he was spending money at a massage parlor, right? This is what he's spending on the campaign. It's not, nothing about it seems like this sort of sexually embarrassing information that is paradigmatically.
You could also say that it's information that he was otherwise entitled to keep private, which might have subjected him to criminal liability had he disclosed it as the statute required. And in this case, in O'Leary versus Trusted ID, in which Judge Agee participated in, the court first noted that TransUnion mentioned disclosure of private information. They also noted that neither party argued that below, and that the plaintiff bears the burden of establishing standing. So we've argued that the argument that this is akin to disclosure of private facts has been waived. But nevertheless, O'Leary distinguished that case as saying that it had to do with impinging on the plaintiff's privacy of association. So I don't think that Davis is a good fit, but there is good fits for what has occurred here, and we can go through what the different potential analogous harms are. Excuse me. Here we go. I apologize, Your Honor. I have numbered papers here. So we were talking about public disclosure of private facts. Basall found that Basall, which is the Seventh Circuit, and I'm sorry, the judge's name's escaping me right now.
Easterbrook.
Easterbrook, that's right. He found that because driver's licenses are given to hotels, medical establishments, rental car companies for security, for voting, and that they're not immutable, that the driver's license are neither embarrassing nor private.
But can't they be used to file for unemployment benefits? The plaintiffs have given statements with various experts indicating that they can be used.
Yes, they can be, but the problem here is that they weren't, Your Honor. There's no harm here, actually, alleged. So there was a discussion earlier about whether or not the mere presence on the dark web of somebody's driver's license number constitutes an injury. In fact, it does not, because that was foreclosed by TransUnion. TransUnion basically said that the risk of future harm, without more, it cannot constitute an injury in fact. And so...
Well, but it could be that the risk of future harm plus expenditure of funds to mitigate that harm could constitute injury in fact. And are you suggesting that unless and until an individual's driver's license number is actually used to apply for unemployment benefits, they would have no standing?
I am suggesting that, Your Honor, because I believe that the district court found that as well, that there was no misuse. At paragraph 52 of a plaintiff's complaint, they list a bunch of things, like you mentioned, unemployment benefits fraud.
Stop for a second. Your position is that until the actual identity theft takes place, there can be no future risk?
Oh, no.
Isn't that, I mean, that just like, that's nonsensical. So how about say that again?
That's not my position, Your Honor.
Okay.
It doesn't, the risk of harm, until some misuse takes place, you have nothing. Once you have some misuse, you have potentially a risk of harm. And you have to take misuse along with other things that might create the imminence of harm and decide whether harm is imminent or not.
What do you think counts as misuse?
So, for example, in the complaint,
Putting it up for sale on the dark web? Is that an example?
well, nothing's happened with that data yet, Your Honor. So, for example, the district court credited the fact that the plaintiffs said that their driver's license numbers appeared on the dark web, but nevertheless, they said they have not alleged any misuse of that information.
Factually, that's correct. But in effect, you could have two different actions here. One is the initial breach. Somebody has your data, and then there's a manifestation of that because it appears on the web, which is a different setting. So why wouldn't that differentiation between the fact of breach and its publication, why isn't that sufficient to say there's at least or both, a present injury and a future threat?
Well, there's not a present injury under TransUnion when there's just a risk of harm without an actual harm you can point to.
What I'm asking is that there may not be a risk of harm when there's a hack, but why isn't it different when it's actually posted for sale? Why isn't that a risk of harm?
Well, because the risk would still entail a series of events that would involve third parties and speculative activity, which makes it inherently not imminent. There's been a series of case law beginning with Clapper, which basically says plaintiffs can't rely on speculation about the unfettered choices made by independent actors, not before the court. In Beck, this found no standing because the plaintiffs, to suffer the harm that they fear, would be required to assume an attenuated chain of possibilities. In Riley versus Iridian, the third court found that.
Do you take back? So the court says in back, in a curious line to me, but the court seems to say in back that a 33% chance of a future harm is not a substantial risk of that harm occurring. I'm not sure that I understand that, but is that the premise of your argument, that if you can't prove that it's something more than 33% chance of the harm actually coming to fruition, that you can't show this substantial risk that Clapper and others require?
Well, the substantial risk that Clapper and others require under TransUnion now is just a predicate for finding something more, and that something more has to be something like emotional distress that's not conclusively pled, or expenditures made in mitigation. And we don't have that here. As a matter of fact, what you have here in terms of allegations of that something more is
So your view is, just so I understand that, your view is you cannot have a substantial risk of a future harm to support a claim, even if the evidence showed that it was 99% likely to happen? Imagine there was extraordinarily persuasive evidence that it's 99% chance that you're going to develop this complication from your medical procedure. And you would say in that scenario that is not a substantial risk of a future harm?
The court can conclude that, and I wouldn't.
I'm asking what you think.
I would not contest that at all, Your Honor. But what that substantial risk does is prompts the next question, which is what else can they show? Because that harm in itself, post-TransUnion, is not enough to confer standing. It can confer potentially, if you can talk about another harm that's going to occur, an injunctive relief remedy, but it cannot provide injury in fact to support a damages remedy. That's correct. Absent
emotional distress or expenditures.
Correct. And here you've got conclusory pled emotional distress, which has been rejected as set forth in our briefs, and you've got essentially an unprecedented type of what they say is mitigation here. It's namely researching their options but never acting upon them, apparently, and reviewing their financial documentation, which everyone is likely to do anyway. And especially when you talk about people like Plaintiff Cardenas, who was already breached in the Equifax breach and presumably would already be checking his credit reports and things like that. That untethered to any kind of expenditures has never been found to be that something more that's required to show a present injuring fact, Your Honor.
Before you sit down, can I ask whether your client has done anything to change the network security following this data breach?
Well, Your Honor, yes, of course. Every breach presumably creates a reckoning for updating and trying to prevent that particular intrusion from happening. But we contest that it's plausibly pled that there was this auto quote tool in the first place, and it's not pled by the plaintiffs that they encountered it, much less that it was still present after the breach or still present now that would entitle them to injunctive relief.
Then was the breach limited to driver's license numbers, or were there other data exposed?
It was limited to driver's license numbers, names, and dates of birth. But importantly, the theory behind this is that a threat actor would have already had to possess some of that data and impersonate the plaintiff in order to perpetrate this fraud. So I would question whether under that circumstance, this is truly a publication, if you're going to do an analogy, because what you have there is someone tricking you into saying, that's not publishing someone's information to the public at large, it's publishing it to the person that they believe it is. So I believe that's a bridge too far. And again, highly offensive is a requirement for this data. We've cited the case law that says that this is not highly offensive. So the question just becomes, how far do you stretch the standard of a close relationship to a traditionally recognized harm to get the proxy harm that has been found in other cases? And I believe I'm out of time, Your Honor, so I will sit down.
All right.
Thank you.
Thank you very much. Ms. Baxter-Cough, you've got some rebuttal time.
Thank you, Your Honors. I think that this court is exactly right, that the analogy in TransUnion is to the type of harm. And there are recent Fourth Circuit cases that confirm that understanding post-TransUnion, namely Krakauer, the TCPA case that says you don't need all of the elements if to get the analogy, that the relevant analogy is to the type of harm, and Nestler, which says that it doesn't have to be actionable. I think one of the discussion about the dark web illustrates that pretty clearly, which is that we argue that the presence of information for Mr. Cardenas and for Mr. Holmes on the dark web of their information does constitute both a present injury, because that information has been sold to a third party that is now making it available for sale in a way that is not simply the breach itself, it is a second.
Well, it may not have been sold. I mean, the hacker may put it up himself.
Or may put it up, that's correct, yes. But has taken an additional action in that situation.
So your position is that it's not the breach in and of itself that creates the injury. It's this posting, this additional action of posting the information.
So multiple courts of appeal have found that the availability of putting it on the dark web is sufficient, so the breach itself would be sufficient. Bonac, the Second Circuit case, does find that. So in that case, the plaintiff alleged that their name and their social security number and no additional information was breached, and that it could be put on the dark web, so that's sufficient.
We wouldn't have to go that far here because the information is
right. Yeah, so you don't have to go that far here because it was placed on the dark web. And that's analogous to the 11th Circuit Brinker case and also the 3rd Circuit Clemens versus Executive Farm case, which overturns in large part the Riley case that defense counsel was referencing, that placement can constitute both a present injury, right, because it's placed on there and that's identity theft, and also an increased risk of harm.
Can you talk for just a second about the sort of private information piece?
Yes.
Right, and whether this is maybe Easterbrook's opinion out of the 7th, but just sort of more generally, like, why do we think that a driver's license number is the type of private information that causes like the same type of harm that we think about? I mean, I show my driver's license to lots of people. I'm old now, so not as often as I used to when I went into bars, but like I still show it all the time. I put it on all kinds of forms, right? It doesn't seem like the type of sexually immoral conduct that, used to be the core of this private information.
Yes, and so I think there are two answers to that question. The first is that Congress has determined that it's private information under the Driver's Privacy Protection Act, and it did so because the use of that number was used for specific harm related to privacy of people, i.e. that it's the gateway to all the rest of your motor vehicle information, including your name, your address, the make of your vehicles, who lives in your house, all of that. And so when misused, it is associated with specific crimes related to that. And then second is, I think, the reference to Davis in TransUnion, which is that when we talk about a traditional privacy harm and the disclosure of private information, the question isn't whether it isn't an objective standard of whether everyone would find that disclosure offensive, but rather that it is in the context and can be and is information that we've determined should be private in that context. So the easy analog is at common law. If you disclose information about if you go into somebody's house or you look in their window and you see something and you disclose that, we actually don't ask the question of what the person was doing in the house. The question what that person's conduct isn't relevant. The relevant part is that it was being misused by a third party, and that's the nature of the harm. Is that it's private and it has been disclosed, right? And not whether some heightened standard for that information. We also obviously disagree with Judge Easterbrook and that description of driver's license numbers.
So in your example, if I looked in your window and I saw you eating dinner, and then I took out a newspaper ad that says she ate dinner last night, you think
I think that's actionable at British common law, so yes, right? And if that's the analog, then that's sufficient to meet that analog. Whether it states a DPPA claim is a wholly separate question, but
no, I'm asking about that.
But it's an injury in fact, yes. Thank you, Your Honors.
All right, thank you all very much. We appreciate counsel's arguments today. We're going to come down and greet counsel, but first I'd ask the clerk to adjourn court for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.